Welcome everyone. I'm Starlin Laura, your facilitator for today's webinar. This webinar is organized by Swords to Plowshares and is part of our Veterans and Behavioral Health webinar series, funded by California Wellness Foundation. We hope today will begin a much-needed dialogue among providers and advocates around the issues of veterans with mental health trauma and subsequent behavioral health issues, and promote a greater understanding of bad paper discharges. Bad Paper is an awareness campaign that Swords to Plowshares began to educate advocates on the impact of less than honorable discharges on veterans' access to health care and benefits. Our panelists will identify how some veterans with mental and cognitive trauma can find themselves receiving bad paper, how this can hinder their access to health care and benefits, and what providers and advocates should do when working with veterans with bad paper. Amy Fairweather directs Swords to Plowshares Institute of Veteran Policy, which conducts public policy research regarding veterans' health, access to benefits, and socioeconomic well-being. She has worked in the field of public policy, in particular, and for trauma survivors since 1999. She received her undergraduate degree from Mills College and her Juris Doctorate from Hastings College of Law. Amy is a member of the State Bar of California. Bradford Adams, staff attorney and legal services manager at Swords to Plowshares, has previously worked with the Center for Justice and Accountability, Harvard University, and the Human Rights Education Institute for Burma. He served in the United States Army as a civil affairs officer in Afghanistan in 2002 through 2003. Brad attended Harvard Law School for his Doctorate of Law after earning his BA in International Relations and Affairs at Johns Hopkins University. One continuing education unit is available for MFT, LPCC, LEP, and LCSW professional licensed in California. During this webinar, you may type a question to the panelist or Swords to Plowshare staff at any time. Simply type your questions in the questions block on the right side of your screen. At the end of the presentation, we will review the questions and comments posted. All participants will be given a chance to ask a question of Amy or Brad by raising your virtual hand. Simply click the small hand icon under the list of attendees next to your name. Please note that this webinar is being recorded and will be archived on the Swords to Plowshares website. Without further delay, please welcome our first panelist, Amy Fairweather.
Hello everyone. Thank you, Star, for the introduction, and thank you everyone for joining us. Just a word about Swords to Plowshares before we begin. Swords was established in 1974 to respond to the needs of veterans. We provide permanent supportive transitional housing, employment and job training, health and social services. We have a women's veteran program and legal services for disabled veterans. The legal services are limited to VA claims and discharge review matters. We are in the San Francisco Bay Area, and we also have our Institute of Veteran Policy, which is very special that we're able to share our experience, our historical memory, institutional memory of the issues with all of you, and we look forward to sharing that today. So this is what we're going to plan to cover today. Part one, which I will present, is talking about the military discharge process, mental health issues related to less than honorable discharge. After that, Brad will take over and talk about the bar to benefits, benefits with the VA, and resources for behavioral health providers working with veterans with bad paper. So first of all, what is bad paper? Veterans who receive a less than honorable discharge from the military are commonly referred to veterans with bad paper. I will just note that this is a term that came up during the Vietnam War, so it's not universally understood among different generations, but it's the most common term aside from the most formal ones. So bad paper by the numbers, this does impact quite a few veterans. Although most veterans do receive a full or honorable, 77%, we have more than 600,000 just between the years of 2000 to 2013 who received a lesser rating. And if we look back at Vietnam, quite a number, 260,000 Vietnam-era veterans were discharged with bad paper. As we go on with this material and how that impacts their access to benefits, we can see that this can have a real impact on those veterans who are still struggling with homelessness and chronic mental illness who may have never been able to get assistance through the VA. So, here are the military discharges by type. Honorable is the top one, and as you can see, most people get that. Now that allows access to all VA benefits. That includes the GI Bill, it includes access to health care if they have a service-connected condition. It also, if they are eligible for benefits associated with a disability, they are eligible for those, so they're good to go. Now the general, they can still get a lot of those benefits, but they don't get the GI Bill. And I don't want to discount how important that is. Many, many veterans, count on the idea that they're going to use that GI Bill to go to school. And we know that school is one of the greatest indicators of success in work. And so to go without that benefit is really quite a burden. Then we're going to go down to some of the other ones. Uncharacterized, who leave very early, other than honorable, some misconduct, but not with a court-martial, bad conduct, and dishonorable. Commonly, people just think there's honorable and dishonorable. As you can see, there's a lot of other options in here, and dishonorable really is quite serious behavior, something that is compared to a felony. I also want to say that when we have the maybes here for VA benefits, that is a maybe without some action on the part of the veteran or their advocate. And of course, Brad will get into that in more detail later on. Okay, why might a veteran receive bad paper? We have to understand this is the military, and the military culture and rules are quite different than those that we deal with in the civilian world. So it can be any misconduct involved in the service member's military service. This can happen for less serious infractions that we might not even think of having an impact on your entire post-career life in the civilian world, like, for example, being late to formation a couple times, having an argument with a superior, having an argument with your boss. Pattern of misconduct. Again, 2 incidents, but they might be not very serious. We also have to think about that we're talking about the UCMJ, the Military Code of Justice. So things like adultery, which we all will agree is not very nice and maybe morally wrong, is not an offense for which you would lose your job and perhaps lose your benefits or pension related to that job. So we're talking about some much more serious consequences for some what we would consider not very serious behavior. Now we go down to the serious offense. Now that can include drug use. And also as we go on in this material, you'll see that drug use and self-medication can be a common comorbidity with PTS and with traumatic brain injury. So we have seen clients here at Swords who had an otherwise clean record, had a couple of tours of duty, diagnosed with post-traumatic stress, and then perhaps smoked some pot or drank to excess, and then received a less than honorable. Okay, other designated physical and mental conditions discharges. So these are discharges that can interfere with the assignment or performance of duty. It's not necessarily something that lays blame or culpability like we were talking with those other bad discharges, but it can interfere with benefits. So we see the personality disorders are the most common of these, and personality disorders could be considered in the process to get service-connected care or benefits would be considered a pre-existing condition and therefore would bar eligibility. That doesn't mean that you could say somebody has a personality disorder and a illness or condition that resulted from service. Also, I want to point out this is command initiated, and so it can be subjective. It can really, really vary from branch to branch, from command to command. Okay, we've got a poll question, so I'm going to turn it over to Star, and she's going to conduct this poll.
Yes, thank you, Amy. Our first poll question will be prompted. What is your knowledge of bad paper prior to this webinar? Please check all that apply. I was not aware of bad paper. I had some knowledge of bad paper. I had extensive knowledge of bad paper. I know someone or work with veterans with bad paper. I am a veteran with bad paper. So as soon as everyone has responded, or in about 60 seconds, the poll will be closed, and then I'll announce the results. All right, thank you all for participating. Most of you had some knowledge of bad paper. So for those of you who have had very little exposure, I'm glad that you're on this webinar, and I hope that the final survey that will be posted at the end of the webinar will really help to collect some more information about if this presentation was valid and if the information was helpful to you, particularly in your professional careers. All right, let's take it back to Amy.
Okay, thank you. Okay, let's talk about willful misconduct. So this is conscious wrongdoing, willful, a known prohibited action that one has taken. However, an injury that can result from drug or alcohol addiction, reckless behavior, or self-inflicted injuries can be considered willful misconduct. So again, when we're thinking about bad paper in the realm of mental health, a lot of these areas are symptomatic of post-traumatic stress and traumatic brain injury and depression, and nevertheless, they can be considered willful misconduct. And this would make someone not eligible for disability payments. I can't stress enough how much of a sort of cruel injustice this is. If someone has sustained an injury, a mental injury, a physical injury because of their service, and then a symptom of that injury causes behavior which ultimately causes them not to be able to get health care and benefits to treat that injury. This is a matter that we really need to look at very carefully and ensure that these service people get the help they need. They are injured, they have served, and Brad's going to talk a little bit later about some of the ways that you can overcome these barriers. I will preface that with the fact that it is not easy. Also, these are line of duty determinations, so again, we're talking about, they can vary very, very dramatically from one command to another, from one branch to another, from the individuals involved in those decisions. Okay, narrative reasons for separation. So these are not the actual discharge status like honorable and less than honorable, etc. These are a narrative reason that explains the reason why they were separated from the military. And for those of you who are really unfamiliar with veteran issues, the term separation is when people leave the military, we call it they separate from the military, as opposed to in the civilian world, we don't say that we separated from our last job. We quit, we retired, we moved on, but this is the terminology in the military. The DD-214 is the discharge paper, which lists your service, your awards, and your discharge status and the narrative reason for your separation. So these can include misconduct, alcohol abuse, rehabilitation failure, homosexual conduct, of course, when DADT was still in effect, which many veterans, are now, still dealing with fallout, having been discharged when that was in effect, and personality disorder. Now, this shows up on this DD-214. This is a document that the veteran may have to show in order to get employment and in other areas. And so, seeing these narrative reasons on this piece of paper can lead to discrimination. It can be a matter of, embarrassment. And as we see here, they can look derogatory. They can certainly be inaccurate. Or if someone had, who really did have a medical condition that warranted medical retirement, do we want to share that? Do we want people to know that? There's no reason why they should. Going back to don't ask, don't tell, having, again, homosexuality, homosexual conduct, or homosexual admission on these papers can certainly lead to discrimination. Not to mention sort of the, the general, I don't know, a feeling of betrayal of having served with honor otherwise, and then being, labeled these derogatory or what would be considered derogatory under don't ask, don't tell terms. It's really, emotionally damaging, which of course can be damaging to one's mental health. And as we go more into bad paper and the mental health link, PTSD, post-traumatic stress disorder, you can see very large numbers, 1 in 5, lifetime prevalence up to 30%. We go back to Gulf War, 1 in 10, 1 in 3 men in Vietnam and 1 in 4 women. 50% of post-9/11 veterans seen at the VA have been diagnosed with a mental disorder. Now, these numbers, because they're diagnosed at the VA, does not include people who either have bad paper and can't go to the VA or choose not to go to the VA. So we know that there are more people out there. I also just want to very quickly say a note about post-traumatic stress disorder. We know that a lot of people call it post-traumatic stress in order to take the stigma away from the idea of disorder. For the purposes of getting health care, getting benefits, it has to be a diagnosed disorder. So for those reasons, you have to have the D. So it's something we go back and forth with depending on the context that we're using it. Okay, women veterans. This is Iraq and Afghanistan, 2008 to 2011. 17% of active duty and 29% Guard and reservists injured, wounded, assaulted, or hurt. 14% reported encountering dead bodies, seeing people killed. 1% fired a weapon, 19% in danger of being killed. Obviously, these are traumatic experiences, which can result in post-traumatic stress. Women also have increased odds of behavioral problems when they're exposed to combat. PTSD, exposure, drug, substance abuse, depression. Also, this is cumulative, so as more and more combat, more and more traumas, the odds of behavioral health problems increase. And this is the most striking risk for PTSD. I'd also say that those cumulative traumas don't all have to be combat traumas. Could be other things, could be military sexual trauma, or other traumas that you would associate with, quote, normal life. So we have women at an increased risk for depression than men and 2 times as likely to experience a major depressive episode. And again, this all links back to what impact it has on the person's behavior and whether that is connected with their discharge. And now we're going to talk about traumatic brain injury. Huge number, 313,816 have been diagnosed with traumatic brain injury. Again, I'm going to say that that's probably, that number is probably an underreporting. The early stages, there was very poor screening. So we've seen more diagnoses in recent years because of better screening, but those people who slipped between the cracks earlier may have never gotten a diagnosis. And also, as we said before, there are people who are not going to the VA, particularly if they have bad paper, and so we would not necessarily know if they have ever been diagnosed. These numbers are coming from who we know about. Also, I want to say that 1 in 3 veterans of TBI significant aggressive behavior during the first 6 months. We go back to the idea of some of the reasons, fighting with a superior. Well, that's aggressive behavior. Is there a diagnostic reason? Is this a symptom, or is this just bad behavior when we think about what we're going to do with these veterans, or at the time, military personnel? Also, I want to say, increase in impulsivity. So that, too, can have a serious impact on the behavior and can impact their discharge. The mental health and traumatic brain injury link. So we have behavioral dysfunction, exaggerated startle response, inability to control reflexive behavior, and high-risk behavior. Let's think about drunk driving. Let's think about, exploding. And these are all reasons why someone could be said to be behaving badly in the military. I'm sorry, I'm looking for one of my notes here. Interference with social and occupational functioning. Occupational functioning, showing up late to formation, showing up late to work. And also some of the medicines used to treat mental health conditions may induce fatigue or lethargy, basic functioning, couldn't wake up to get to that formation on time. So it's very clear that these symptoms can lead to what we were talking about, minor infractions, patterns of misconduct, and even what we would consider more serious offenses like using drugs in the case of self-medicating, like getting into altercations, which we would consider more serious offenses, but again, if we look at what the reason is the reason from an underlying injury that was sustained during service. So, as I was saying, these behavioral issues from in-service trauma certainly result in infractions of unit disability. Military often doesn't treat these disciplinary infractions as symptoms. They're simply bad behavior. The mission of the military is to function as the military. It is not to act as a public health organization, or in the VA's case as a source of medical care. While they do provide medical care, it's not really first and foremost. It's getting the mission done. It's getting rid of this bad actor so that they can have another person in their unit who can do their job. And of course, while there's been a lot of public education about PTSD, about traumatic brain injury, still remains the stigma that someone might be a malingerer, or I could say many things that would be much worse words that are certainly used in the military to describe somebody who's not pulling their weight. But again, these can go unnoticed, and then also there still is the pride of service members who say, you know, I'm young, I'm okay, I don't need any help, other people can do it, I can do it. You know, why should I go get help? Everybody's hurt, and therefore, you know, don't seek the services. And when they do seek the services, perhaps they're not met with a caring hand in terms of really getting those services. And again, the command may not believe that still goes on. So even if military has acknowledged a disability and the person is going through medical separation, which can be a long process, at any time during that medical separation process, if there's some conduct that is inappropriate under the rules, they can stop that medical separation and just go to a misconduct discharge. For those of you who are not familiar, the medical separation process is, you know, it can last months, and it's a time during which the service member's health is assessed, whether or not it could be improved or treated, and whether or not that service member can serve given that injury. And if they cannot, then they are medically separated. But again, during this process, if behavior jumps in, they can stop it and just kick them out, and they will lose their benefits and their access to care. There's a really, really good and very, very moving and sad story in the Gazette. It was the Denver Gazette in 2013. I really suggest you go look at it. Some really alarming stories of people who were discharged with bad paper, with very serious behavioral problems related to their mental health. It's a long piece, and it really goes into not only the lives of those specific veterans and their families, but also the processes. It's very good, and I believe it won either a Pulitzer or one of the very important awards, and deservedly so. Okay, substance abuse comorbidities, symptomatic behavior, post-traumatic stress disorder, military sexual trauma, combat exposure, other mental illness associated with increased drinking. This should be news to no one. These numbers, though, the Marines who deployed to combat diagnosed with PTSD 11 times more likely to receive misconduct discharges than those that didn't. 8 times more likely to have substance abuse discharge. You know, is there a connection there between their PTSD and that behavior? And more importantly, and I think we'll go through this a little bit with Brad, should that matter? You know, if someone's served and they are ill, we should take care of them. So that goes more into the advocacy that we're doing around this bad paper and trying to overcome these bars. Again, drug use, the service member is culpable, so even if it is self-medication, that is misconduct. Don't ask, don't tell. We talked a little bit about this earlier. Under don't ask, don't tell, most people received honorable discharges. Some of them had under honorable general discharges under honorable conditions. Those people, of course, would not get their GI Bill. And then other than honorable based on aggregating factors, had to do with their sexuality and harmless behavior, hugging on base, hand-holding, which would be considered engaging in homosexual behavior. Again, also, this would be noted on the DD-214, and depending on the veteran's experience, that could open them up to discrimination. That policy has changed, of course. However, the people who were discharged under the policy during those years, there's no reparations, there's no compensation for what they have lost. There is guidance on how to handle those requests for upgrade. I think Brad might talk a little bit more about this later. It's not an easy process. There were some calls to have just blanket anybody who was kicked out under DADT to have their discharge upgraded, but that was rejected based on the fact that there could have been another reason other than the homosexuality, which contributed to their discharge. So that's another advocacy area where we'd like to see better outcomes and easier outcomes for those veterans who lost their benefits. Military sexual trauma. I think you're probably all familiar with this term. I do want to say that it includes any kind of trauma. It can be sexual harassment, aggressive sexual harassment, and assaults. We also know that it happens far, far, far too often in the military. I do want to note that people think of this as an issue for women veterans, which it certainly is. It is actually the number of individuals who have experienced military sexual trauma is higher for men. The percentage is higher for women. That only makes sense when you look at the overall demographics of the military, but this is certainly not an issue that's limited to one gender or another. Now, sadly, many people who report sexual assaults have ended up getting less than honorable discharges themselves. Retribution for upsetting the unit order, being accused of or labeled with personality disorder. This has happened to many of our clients here at Swords. Of course, that would be considered a pre-existing disorder, and so they wouldn't have be eligible for disability compensation. Male-on-male rape victims, again, I was talking about the gender issues prior to DADT, be discharged for homosexual conduct as a result of being sexually assaulted. Again, just a terrible, terrible injustice, and the impact on those individuals is just tragic. So again, also the compensation, the benefits, it's not just the military sexual trauma alone. They have to have experienced trauma that resulted in post-traumatic stress disorder, depression, anxiety, physical injury, panic attacks. So you cannot just simply say that you were subject to trauma. You must have those diagnosed disorders in order to receive compensation. And compensation may not be available if there's a misconduct discharge. Again, Brad's going to talk about that in more detail. Again, it's not easy, and particularly it's not easy in this case because going through the military trauma, the sexual trauma can be a very triggering process. So if you're working with veterans in this area, being prepared for that is very important. That this is a really, really hard, long, drawn-out emotional process for them. Okay. So other fallout, overrepresented in state and federal prisons, shouldn't come as a surprise to anyone. 40% of incarcerated veterans less than honorable discharges. That's huge, especially considering the overall numbers of veterans. The other is that we're seeing the rate of suicide for veterans outside the VA is increasing. So outside VA, 30% more frequent suicide than those enrolled in VA care. And of course, if someone has bad paper, unless they go to great lengths to address that. They are not eligible for VA services. So again, a really cruel bar. Okay, we have another poll question, so I'm going to turn it over to Star again.
Thank you again, Amy. All right, this is the second poll question. For those of you who know someone or worked with someone with bad paper, how has this impacted them? Please select all that apply. Has it limited their access to VA services and benefits? Has it made them ineligible for VA services and benefits? Has it limited their ability to find employment? Has it impacted their mental health? Does it have little or no impact? Again, the poll will be open for about 60 seconds. So once you've answered all of the questions, then I will come back and discuss the solutions. All right, the results are in. It is interesting to note that limited VA access and benefits is what this presentation is primarily about, and we're actually going to get further into that during the second half. So at this time, let's go ahead and turn it back over to Amy.
Okay, thank you. So I want to talk a little bit more broadly about the fallout of bad paper. And, you know, that's denying veterans this health care and benefits, aside from being, you know, sort of cruel, it's bad public policy and bad public health policy. You know, this can exacerbate their conditions. The other thing it does is it shifts the burden of care to nonprofit organizations, private care, and local clinics. You know, aside from that being an issue, when we look at limited funding here in California, we have, you know, the public health, mental health system is always, you know, is never, you know, overfunded. Let's put it that way. You know, there's a lot of people who need help. So it's bringing that burden into the community, reducing resources for everyone, and then also those entities may lack any sort of cultural knowledge of what the issues are or the infrastructure to deal with them. So we're looking at this from a number of angles in terms of our advocacy here, which is one is to change the burdens with regard to changing a discharge status, particularly within the VA system. The other thing we're trying to do is to provide this public education so that people who are out there practicing wherever they're practicing can have some cultural knowledge and some resources and can come to us to ask questions when you come across these veterans in order to give them better care. So with that, I'm going to turn it over to Brad, and I want to thank you for your attention.
Thank you, Amy. Now we'll turn it over to Brad for the second portion of the presentation, where we'll focus on the effects of bad paper on VA benefits.
Hi everyone, this is Brad Adams. I am a staff member at Source of Plowshares and an attorney. I'm also an Army veteran. I'm going to address how bad paper affects access to VA services and ways that care providers can increase access to services for veterans with bad paper. Here are the three takeaways that I'd like everyone to come away with. First, service members with bad paper might or might not be eligible for VA benefits. The VA decides. There's a myth that everyone who serves is recognized as a veteran by the VA. This myth is common in the public, and it's not true. A second myth is that only veterans who received honorable discharges may be recognized by the VA as veterans. The VA has no choice in the matter. It's just the military who provides a characterization and that determines eligibility for VA services. This is also a myth. It's also not true. I hear that often, even among staff of the VA. For veterans with bad paper, the VA will decide eligibility. The second takeaway is that the veteran has to request that the VA make this decision. The VA does not make this decision automatically upon discharge. The veteran has to ask for it, and they have to ask for it in the right way to make sure that it happens. Until the VA makes this decision, the veteran is ineligible for most VA services. The third takeaway I hope people will come away with from this is that caseworkers and mental health professionals can make a big difference for veterans in this situation. They can help make sure that that decision happens to determine whether or not they're going to be eligible or not, and they can provide mental health information which can affect the outcome. So first I want to give an overview of how the VA decides who is going to be recognized as a veteran and who is going to be eligible for services. Not everyone who wears a uniform, not everyone who signs up is a veteran according to the VA. The VA only recognizes as veterans and only extends services to people who served on active duty with federal service and were discharged under conditions other than dishonorable. They also have to have a minimum time in service. So first to address those first couple of terms in case people aren't familiar with how they play out. There has to be active service. That means a full-time, not for training service. If you are a reservist or a National Guard service member, typically you do training 1 weekend a month and for a couple weeks each year. That's considered inactive duty for training. That does not establish eligibility for veteran benefits. Only if you are mobilized to full-time active service will that establish veteran eligibility. So, for example, I was a reservist. I spent some years just drilling on the weekends and in the summer, and then I got an order to spend a year in Afghanistan. That year in Afghanistan was active duty, established veteran eligibility. Someone could spend an entire career, 20 years in the reserves, and never get called up. That would not be established active service for VA purposes. Second, it has to be federal service. Reservists work for the president. That's federal service. Members of the National Guard work for the governor. That's not federal service. That's state service. A member of the National Guard can be ordered up to spend 1 month doing, here in California, they might do wildfire response or flood response. That would be active service, but it's active service for the governor, for the state. That's not federal service. That same person could be called up to spend a year in Afghanistan or Iraq. That would be federal service. It's only federal active service which is going to establish VA eligibility. And second, and finally, and this is what this presentation addresses, there has to be discharged under conditions other than dishonorable. There's also a minimum time in service requirement which relates to this. I'll address that later. The key point for this presentation is what it means to get discharged under conditions other than dishonorable. It would make a lot of sense, it would be very easy if that term dishonorable referred to the dishonorable discharge. The sort of plain English meaning of this is that if you get a dishonorable discharge, you're excluded, everything else you're included in terms of getting access to VA services. That is simply not the case. This term in statute gives the VA a totally separate, independent responsibility for making an overall assessment of the veteran's service to give them a thumbs up, thumbs down decision on whether or not their service was dishonorable or honorable. And if the VA finds that overall their service was dishonorable, then they're supposed to exclude that person from VA benefits. If the VA finds that their service was honorable, they're supposed to be included for most VA benefits. This establishes basic eligibility. The VA sometimes refers to this as VA healthcare eligibility. So if any of you work in the VA, you may have heard that term. That's synonymous. The reason why the VA uses that term is because there are no additional eligibility requirements for VA healthcare. Once you satisfy these basic eligibility terms, you're eligible for VA healthcare, and so basic eligibility is used interchangeably with VA healthcare eligible. So this definition of a veteran, this criteria for basic eligibility, gives the VA a separate responsibility to assess whether service is honorable or dishonorable, separate from the discharge characterization. Why have two systems? Why separate that? This decision was made by Congress in 1944. Prior to that, the discharge characterization given by the military determined VA benefits eligibility, and in 1944, they spun it off. They said the VA gets to decide separately. Why do that? The reason is because the Congress at that time recognized many of the things that Amy just discussed. The VA recognized that, the Congress recognized that the military, when making discharge decisions, sometimes makes expedient and sometimes unjust or erroneous discharge decisions. There might be someone whose behavior really is impermissible, it really is misconduct by military standards, but that person might be suffering from a mental health condition, that person might have extenuating circumstances, or that person might have a sufficiently honorable service prior to that period of misconduct to justify eligibility for VA services. The Congress recognizes that the military is going to and needs to make expedient decisions, that the VA should decide separately whether or not overall that person should be eligible for VA services. The way to ensure that veterans are not stuck for life with whatever expedient decisions a commander made during service is to give responsibility for making a decision to the VA, and that's where it lies. It lies with the VA. So Congress said, all right, VA, you're going to decide who overall served dishonorably or honorably, and that decision is going to determine basic eligibility for VA services. It was then up to the VA to establish criteria for how they're going to make that decision. And it gets pretty complicated. I'm going to provide a simplified version of how the rules play out. Here are the military discharge characterizations that the military can provide. Amy covered those previously. The VA applies its regulations in the following way. If the person has an honorable, general, or uncharacterized discharge, the VA presumes that they are honorable for VA purposes, what the VA calls HVAP. If the person has a dishonorable discharge from the military service, the VA presumes that they served dishonorably for VA purposes, or DVAP. For those two discharges in the middle, other than honorable or bad conduct, the VA gets to decide if they are going to receive VA benefits or not. To give a reminder of the numbers that VA provided before, that middle category is actually pretty big. Since September 11th, about 145,000 people have signed up, served, and discharged, and they fall in that middle category where it's the VA who will decide whether or not they receive recognition as a veteran by the VA and therefore veteran benefits. So for that middle category where it's the VA who's going to decide if they are in or out, what standards the VA have, what standards do they apply. Here are the primary categories that they look at. If the misconduct which led to a discharge falls into any of these categories, the VA will decide that service overall was dishonorable. And they're listed basically in the category by ranking of how commonly they're used. The most common standard by far is willful and persistent misconduct. So if the VA looks at the service record and decides that it wasn't just one minor isolated act of misconduct, that conduct was persistent, meaning it happened repeatedly over time, and that it was willful, it was purposeful, then the VA is going to decide that this indicates that service overall was dishonorable. In my experience and in my opinion, they apply this really severely. So even two acts of misconduct can be considered persistent because it happened more than once. And the VA finds that anything which is a conscious act is willful. And so knowing that the military services can give disciplinary actions for really minor misconduct, showing up late to formation once, speaking to a superior officer, a non-commissioned officer, in a way that's considered not sufficiently deferential. These really minor acts can count as misconduct. You have a couple of those. Now you have willful and persistent misconduct. All of a sudden, 2, 3, 4 years of service, 1, 2 deployments are negated. That the VA can look at that and say, well, this is willful and persistent, therefore I'm going to consider your overall service to have been dishonorable, and you will be excluded from most VA benefits. There's ways to counteract that I'll talk about in a second, but I want you to know that the standard is very strict. And a little bit of commentary here, I think it is, in my own belief, much too strict. I think that people who sign up and serve at this time when service is voluntary deserve a benefit of the doubt in terms of whether or not their overall conduct deserves recognition and to be recognized by the VA, where they deserve to receive services by the VA. I believe, and we are working with the VA to try to make a standard that's a little bit more judicious and looks more at the broader context of their service. But that's the standard right now. Second item which the VA can apply to find that service was dishonorable is whether it was an act of moral turpitude, and this generally means a conviction of a felony or some type of act that involves dishonesty, like writing a bad check or something like this. There's a few more down here. The last one there, aggravated homosexual conduct, is still in the books. Obviously that is no longer acceptable, and the VA needs to replace that, eliminate it, but they haven't done so yet. So the VA is gonna, when someone walks up and they have one of these middle-of-the-road discharges, other than honorable discharge or bad conduct discharge, they're going to request their military service record, and they're going to read their service record and see if any of these descriptors apply to the circumstances of the discharge. And if it is, then they're going to conclude that the service was dishonorable, and therefore the person doesn't deserve recognition as a veteran. There is one exception to this. If the VA finds that the person was insane at the time of that misconduct, then they're not going to hold that misconduct against the veteran. And I put the word insane here in quotation marks because I recognize that's not a proper clinical term. I imagine a lot of people on this webinar are trained behavioral health, mental health specialists, and so this term, you might sort of bridle at seeing this term, but that's the term in VA rules. If you're going to engage with the VA rules in order to try to get a good outcome for veterans, you have to work with, you work in the boxes that they provide, and that's the box they provide. Fortunately, they provide a definition because that isn't a clinical term and doesn't have a clinical definition. There is a sort of legal definition, and here's what it is. I've quoted all of it so to give you an idea of exactly what they mean by insanity. And the last two lines there, I think, are key and are the ones where veterans might be most likely to get an exception to the general rule that's going to be applied. If at the time of misconduct the veteran exhibits due to disease a more or less prolonged deviation from their normal method of behavior, or has so departed from accepted standards of the community to which by birth and education he belongs as to lack the adaptability to the social customs of the community in which he resides. To translate this into somewhat plainer English, if they have a mental health condition which prevents them from being able to adapt to military discipline, then the VA can recognize that that misconduct should not be held against them for the rest of their lives. The catch is this has to be a medical diagnosis. It's not enough for the veteran to say these magic words. It's not enough for an advocate to say these magic words. Even though this is not a clinical term, insanity, the VA requires this opinion to come from a mental health professional for them to consider it. So mental health professionals, behavioral health professionals can play a huge service for veterans with bad paper by providing this opinion, if you believe it, if it is in fact the case. If you look at their service record, look at the misconduct that was documented in service, talk with the service member, what was happening at that time, how are you feeling, how are you feeling now. If a mental health professional can link the current disability back to service, can say the TBI, the PT, post-traumatic stress, the depression, anxiety experience now, that began in service, and that the behaviors exhibited at that time were manifestations of that early mental health condition, and that behaviors were preventing that person from appropriately conforming to military discipline. That opinion from a mental health professional can open the door for a veteran trying to get access to VA care and services. This is an uphill battle. Of the veterans who do request this decision, so this is veterans with other honorable or bad conduct discharges, they go up to the VA, they ask for a determinant of eligibility, and the VA makes that determination. The VA rejects them 80% of the time. 80% of the veterans who walk up with a bad paper ask to be considered for eligibility. 80% of them are turned away by the VA. And so leveraging this exception can be very important, can make a huge difference for veterans. The VA is very quick to find that misconduct in service was willful and persistent or moral turpitude, and by very quick I mean 80% of the time. This exception here can help a large number of people get access to VA care. It requires a mental health professional just to write a letter saying, I've been working with this person, I understand their symptoms, I've looked at their record, and I believe that at the time of the misconduct, because of this mental health condition, the service member was unable to adapt to military discipline. It doesn't always work, but it can be the only thing that will work. For people who are uncomfortable making that statement because it's not clinically proper, it feels unprofessional to make this kind of assessment, which isn't actually a proper mental health diagnosis. Even sort of stating the elements of it without giving it that insanity characterization, even stating the elements of that can be very helpful. So a statement that a mental health disability existed at the time of discharge, I think very often mental health professionals are willing to make that assessment by talking to the patient, talking about their experience, and looking at their behavior at the time. So a statement that the mental health disability had the origins during service can be very helpful. A second statement that the kind of misconduct that was observed is a typical manifestation of that mental health disability. So for example, we often work with veterans who are discharged for a single drug use and now have PTSD. A statement from a mental health professional saying, this person has PTSD. It started in service. Marijuana use is a very common way to self-medicate for early symptomology of post-traumatic stress disorder. In my opinion, that drug use was consistent with the early symptoms of post-traumatic stress disorder. You don't have to go all the way to say the person was insane by the VA's definition, but even those elements, which if you are willing to say them, that can make a huge difference for veterans trying to put themselves in the 20% of the successful claimants rather than the 80% of those who are rejected. I want to highlight what's missing from here. So in the previous slide, I'm going to go back one slide. In the previous slide, these are the standards which, if the VA thinks they apply, the VA is going to presume that service was dishonorable, and willful and persistent misconduct is so broad that it catches by far most of the people who put themselves out there to be evaluated for VA eligibility. 80% of the people are excluded on one of these terms. There's one exception, insanity, and maybe we can expand that and just apply it more broadly as a mental health exception. There is no consideration for whether the person was deployed, no consideration generally for whether or not there was mental health stress other than insanity, no consideration for whether there's personal or operational stress or family stress. Generally speaking, the VA does not on its own initiative, or it's not required by its regulations, to consider extenuating circumstances like that. And this is really unfortunate, and we're trying to work with the VA to change that, to open its eyes, to consider these more often. A letter from a mental health professional which states those personal stressors, states the fact that early symptomology may have been present, and if you're willing to, states that symptomology prevented the service member from adapting to military discipline to fit within the VA insanity definition, that can be huge because the regulations don't require the VA to consider that on its own. So that, very briefly, is the standards that the VA uses when looking at someone with bad paper to determine if they're going to recognize them as a veteran or not. You have the several characterizations of the misconduct. Most common is willful and persistent. You have this one exception, insanity, which I encourage advocates to try to use, or at least speak to that through alternative statements that don't actually use the term insane, but refer to the basic elements of that. That's how the VA is going to determine if someone was served honorably or dishonorably, and right now 80% of the time they get rejected. There's a second element here that relates to misconduct, and so I want to address it. That's the significance of the duration of service. There is an additional requirement since September 1980 that people have to serve a minimum time in service in order to be eligible for VA services. Prior to that, basically one day in service and you would be recognized as a veteran. After that, you have to have served 24 months in active service or the full-time order to active duty. So in my case, I was a reservist. I was ordered to active duty for 1 year. It was less than 24 months, but I did everything that was asked of me, so that satisfies the minimum time in service requirement. Alternatively, you have to have a medical discharge or a service-connected disability. So correctly, I think, the VA recognizes that if you were discharged early but you have a disability from service, you should still get a VA eligibility for those disabilities because that sacrifice of having been disabled shows that you have done enough to sort of earn your way into VA benefits, even if you didn't serve a full 24 months. This overlaps with the problem of bad discharge because very often people who are discharged with bad paper are discharged in less than 24 months. So someone who may have served 18 months in service and then gotten an other than honorable discharge, they have two hurdles to pass. One is the VA has to look at their service and decide that they served honorably overall. That gets over the discharge characterization hurdle. The second hurdle is they then have to show that they served the minimum time in service. Because it was 18 months, if their actual commitment had been more than that, they did not serve 24 months, they did not serve the full-time order to active duty. However, if they get a service-connected disability, that will get them around this requirement and they will be accepted for VA services. A second thing to mention here, and this can be important, is that even if someone has a bad paper discharge, even if the VA looks at that and decides for whatever reason that this discharge makes the misconduct which led that discharge makes their service overall dishonorable, that person can nevertheless be recognized as a veteran and be eligible for VA services if they had a prior good enlistment. So someone enlists a 3-year contract. After 3 years, they decide they want to stay in, and so they sign up for another 3 years. 2 years after that, so this is now 5 years into their military career, they get a bad discharge. The VA looks at that bad discharge and says, yeah, I think service was dishonorable. They will be found DVAP, dishonorable for VA purposes, but they completed that first term of service honorably, and that establishes eligibility for VA benefits. So I want to put this on everyone's radar. If you're talking with someone who has a bad discharge, but they've spent several years in service, it's worth looking into how long their initial term of service was. And if they surpass their initial term of service, so that they may have completed that initial commitment without misconduct, then they may be able to get VA benefits and services regardless of how the VA evaluates their final period of service. So these are the criteria for how the VA makes its decision, and I hope I've underscored that it's an uphill battle. 80% are rejected. There is an opportunity to put yourself in that 20% by highlighting the mental health context, and behavioral health, mental health professionals can play a very important role in putting that information before the VA because it has to be a health opinion, mental health, behavioral health opinion, and without that, the veteran may really be floundering. A second issue is how to make sure that decision even takes place. What I want everyone to understand is that it is not automatic. when someone is discharged from the military with bad paper, the VA does not automatically assess their service to determine if they will be recognized as a veteran. When someone walks up to a VA hospital and asks for care, unfortunately, frequently, the VA does not automatically initiate the process for making that decision. So you can have someone who is potentially eligible, who, when finally an evaluation is done of their service, they are found to have served overall honorably. But from the day they leave service until that decision is actually made, which can be a long time if they don't ask to have that decision made in the right way, the VA won't make that assessment on its own, and until the VA makes that assessment, it presumes that that person is ineligible. So the VA has an eligibility database. It shows what someone's discharge characterization was. If someone with another honorable discharge goes to the hospital and asks for health care, the VA eligibility worker can pull up a database and can see that that person does not have an eligible discharge, has not yet received an evaluation, and so, for the time being, is not eligible for VA service. They are presumptively ineligible until proven eligible. So you have to ask the VA to make this assessment. There's two ways to do that. The first way, and it's the most reliable way, is when the VA files a claim for a VA cash benefit, or for those of you who are VA employees, this is a VBA benefit as opposed to a VHA benefit. So compensation, pension, voc rehab, home loan. When you fill out a veteran fills out one of those forms and sends it in, the VBA, the benefit side, receives that. They see that there is a potentially disqualifying discharge that will automatically trigger the process for evaluating the service to determine eligibility. So even if the person does not actually want pension or compensation, the most reliable way to determine general eligibility is to file and file for compensation or pension, and that will trigger the evaluation of their character of service. If you are trying to help a veteran get eligible, you can walk them through this process, file that claim with them, and then if you are or have access to a behavioral health or mental health professional who can write one of these evaluations I was talking about before, send that letter in with the application in order for that information to be before the VA when it makes its decision. That might increase the chance that the person is found honorable and found eligible for VA services. That's the most reliable way for it to happen. It's automatic once you file one of those claims. The second way for this to happen, which is less reliable, is when the veteran applies for VA health care. This is how it's supposed to happen according to VA policy. The veteran goes to the eligibility office. They fill out a VA Form 1010, which is the health care benefit eligibility request form. They provide that to the eligibility worker. The eligibility worker completes an internal VA form, the VA Form 107131, saying, hey, this person has a potentially disqualifying discharge. It asks the VBA to make a decision on eligibility based on discharge. That triggers the VBA's inquiry. The VBA will then send the decision back to the VA when they've completed it, and then the VHA will inform the veteran that they're eligible for health care. I have to stress here that this often does not actually happen. I've heard of and I've accompanied veterans experiencing this when they walk up to the VA hospital and they say, I'd like VA health care, and instead of hearing from the VHA eligibility worker, okay, hi, thank you for your service, you might or may not be eligible, let me fill out some forms to determine eligibility. Instead, what they're told is simply, you're not a veteran, you are dishonorable, I can't help you. I mean, I've been present with veterans when they hear this from eligibility workers. And not surprisingly, many veterans in that situation don't then rise to the occasion of insisting on their rights. They've been told that they were dishonorable. That feels bad, and most just walk away and never pursue it any further. I want to give some data about the impact of these hurdles to even being considered for eligibility at the VA. We know that 45% of post 9/11 veterans are getting some kind of VA benefits, healthcare or compensation. Of the 145,000 service members who have potentially disqualifying discharges, the VA has only considered eligibility for 10% of them. Now, I don't know exactly how many of those 145,000 actually sort of went to that eligibility office to sort of put them out there and then were turned away. But that difference, 45% utilization for people with overall versus 10% of veterans with bad paper where the VA even considers eligibility, says to me that there's big hurdles here. That that 10%, really we should have about 45% of those veterans who may potentially need or benefit from services, and they're just not even getting to the point of being considered for eligibility because they're being given misinformation, because when they go to an eligibility worker, the eligibility worker does not automatically trigger or start an evaluation of their eligibility. What this means is there's a huge role here also that caseworkers, social workers can play. I suspect, well, here's what I can speak only for myself, a lot of the veterans that I work with who received bad paper walked up to a VA facility a while ago and were turned away. The VA never started a character of discharge review to determine eligibility, and they just never tried again. They come to me sometimes many years later, and I help them walk through the process of actually getting it done, usually through that first pathway on the slide, which is just applying for a VBA benefit, even if that's not what they want, even if what they really want is health care, or alternatively, making sure that the second process actually happens at the VHA eligibility center. This can be a huge service to those veterans who fall between that 10% and that 45%, the 45% who probably benefit from services and want them versus the 10% who actually receive that determination of eligibility. So I hope that people watching this webinar will realize that there's a valuable role they can play in just making sure this actually happens, making sure they didn't simply get rebuffed without getting a proper determination. Even if a veteran is found to have served dishonorably by the VA, the VA does its determination, and the veteran makes its best shot, and the VA simply turns them down. There are certain benefits that are available to DVAP, dishonorable for VA purposes, veterans, and so I want to make sure people are aware of these. These are available in the meantime while you're waiting for the VA to make a determination on eligibility, and they may be available after that determination if it comes out negative. First, medical care. You can get treatment for service-connected disabilities if that condition has been service-connected. So let's just take a somatic injury, a leg injury in service. They file compensation to have that leg injury service-connected. The VA first looks at their discharge, decides that their discharge is disqualifying. What the VA is supposed to do is then proceed to determine if that injury is service-connected anyway. If it is service-connected, they'll send a letter back to the veteran saying, okay, we looked at your service, we think you are dishonorable for VA purposes, we're not recognizing you as a veteran, you're not getting most VA benefits, but that leg injury is service-connected, you can go to any VA health center and get treatment for that injury. The same is true of a mental health condition if you get it service-connected. Second type of medical care that's available regardless of discharge characterization is any treatment related to military sexual trauma. That does not need to be actually service-connected. If the patient simply states, alleges that these physical or mental health conditions are related to military sexual trauma, the VA will provide treatment, including both medical treatment and counseling for those conditions. Second, counseling. I don't know how many people on the webinar work for the VA, but I imagine some may, and I wouldn't be surprised if many of you work for vet centers. But for those who don't, vet centers are a service provided by the VA. They are separate, usually from medical centers, or usually downtown, centrally located areas. They are storefront counseling centers. I believe that they do not provide any medical treatment, no prescriptions, but they provide counseling. Services at vet centers, counseling services at vet centers are available to any combat veterans and any survivors of military sexual trauma, regardless of discharge characterization. Third, housing, the grant per diem program, that's basically emergency homeless beds. At the moment, this has been changing, but at the moment it's available to any veteran unless they have a fully dishonorable discharge, but they have to have that minimum time in service. The SSVF program, that's rapid rehousing, also available to any prior service member unless they have a fully dishonorable discharge. At the moment, they're not applying the minimum time in service requirement. Finally, non-VA benefits, and here, this is a bit off topic. This is not, it's about non-VA benefits, but the VA has its definition of veteran. None of us are required to apply that definition in our own work, our own life. Here at Source to Plowshares, anyone who ever signed up is a veteran. We extend everything we can to everyone who comes in the door, and you can do the same. There's no legal obligation on anyone other than VA staff to apply the VA's definition. State benefits don't have to limit themselves that way, and of course public nonprofit services don't have to limit themselves that way. So I want to review again how service providers can help. First, help make sure that the evaluation of a discharge actually takes place. You can do that either by filing a claim or by making sure that the health center eligibility staff follow its regulations, to follow its procedures to request a determination to take place, and I've cited there the VA policy that tells them how they're supposed to do that. Second, mental health providers can help by providing information, opinions which support a conclusion that mental health disabilities at the time of that misconduct explain it or mitigate it. Ideally, you would be willing to use the VA's own language on this by using this term insanity, but even if you're not willing to use that term, an evaluation can be very helpful. The standard, as far as the VA is concerned, is as likely as not. So we're talking about things that happened in the past. You don't really know exactly what happened in the past. You don't have to be entirely certain. You don't have to have medical certainty. If you are even 50% certain that the person had a mental health disability at that time, if you're even 50% certain that the behavior shown at that time was symptomatic of that mental health condition, then that's enough for the VA. You can say, I believe that it is as likely as not, or it is at least as likely as not, or it is more likely than not that the person had disability at the time, that their behavior was symptomatic of that disability. If you're working for the VA and you're not sure if you are allowed to make provide an evaluation like that, you are. I've cited here the VHA directive, which instruct its staff to respond to requests from any veteran patients asking for evaluations like this. Of course, you can't say anything that you're not competent to say, they don't feel is true, but you are permitted by the VHA to respond to requests for evaluations, even when those evaluations are being requested, to support a claim for VA benefits. So, recap, what I hope you come away with, veterans with misconduct discharges may or may not be eligible. The VA will decide their eligibility. It's not only up to the Department of Defense. The VA can extend eligibility to most veterans with bad paper, even without having the Department of Defense change its mind. But the veteran has to ask for this to happen, and until the veteran asks for it to happen, the VA is going to treat them as if they are ineligible. They need to ask in the right way, and service providers can help make sure that happens. In addition, service providers can provide relevant medical information to take advantage of exceptions in the rules, exceptions that allow the VA to recognize that mental health conditions at the time, that other extenuating circumstances might explain or mitigate the misconduct during service. One last topic briefly, we would call cultural competency, working with veterans with bad paper. During the poll, half of you, I think, said that you were currently working with veterans with bad paper, so you're probably familiar with this. But just to hit on some topics. There may be underlying trauma, as Amy talked about, combat trauma, sexual trauma that that prompted or triggered or caused that misconduct. So when you're talking about the misconduct, be aware that there might be something buried there that you have to be careful about. Second, the denial of recognition may itself be separately harmful, which is to say someone signed up, served, deployed, in combat, maybe had a very hard time of it, come back, they're told that they're not a veteran by the VA, or they have been told that by the VA or by other people. That can be shameful. That can be harmful. This is a sensitive issue to talk about. The language you use can help mitigate that. Some people, unfortunately, use terms which I think are inherently harmful. You are dishonorable. I've heard that. It's not legally true. It's not helpful to say that. You are a non-veteran. That is technically legally true as far as the VA is concerned, but that's also not I don't think it's a respectful way to address some of the people we're talking about. Alternative ways to refer to this group of people: a non-VA eligible veteran. They're a veteran under the the plain English term, but the VA doesn't recognize them as so. You can say that you're a non-VA eligible veteran, or simply a former service member. The last bullet in here, I'd like you to understand a lot of people with bad paper have internalized misinformation. And so I hope that you will take away some information from here and make sure that people you work with are aware of the actual situation. A lot of them have been told that they're never going to get anything. That's not true. They simply have to ask the right people in the right way, and they may get something. Similarly, a lot of them have been told that somehow their discharge will automatically change in a certain number of years. That's also not true. There's a whole separate area of law, which is discharge upgrades, which is going back to the DoD, asking them for a new discharge with a new characterization. I haven't discussed that because that's a more legal process. It's more complicated, and I wanted to tell behavioral health providers and social workers things that you can do to increase access to services, and so I focused on things that you can do through the VA. There is this separate pathway called discharge upgrading. It's harder to do, they're less frequently successful, and it's more legally administratively difficult. There is a myth that those discharge upgrades happen automatically. They do not. That's also some misinformation that may have been internalized by folks with bad paper. That's the end of my top part of the presentation about how bad paper affects access to VA care and services, and what social workers and mental health providers can do to increase access to care and services. Star, I'd like to turn it back to you.
Hi, thank you, Brad, and thank you, Amy, for your informative presentations. And now we'd like to open it up to discussions and questions from the audience. If you haven't posted any of your questions, please feel free to ask them in the chat block or the question block to the right-hand side of your screen. During the presentation, we've received several questions and comments, and I'm going to go through them. However, we've received several, and so many that we want to, take an extra moment to let you know that if you stay on the webinar through the Q&A, that we will increase the number of CEU credits from 1 to 2. So we've got questions in several different categories. We've got questions around military discharges, basic eligibility benefits, some specific to Guard and Reserve, some specific to service members serving less than 24 months, and then we've got several comments. So we'll just get started from the very beginning, and Amy or Brad, please feel free to answer. First question is the discharge process only for current discharges? How does this apply for Korean War veterans?
Brad, I think you should go ahead and take that.
Okay. So the rules around discharges do change pretty frequently. Actually, it can be changed by Congress, they can be changed by the Pentagon, and then each service has their own regulations, and they change periodically. I think what Amy presented here hasn't changed substantially since the 50s probably, in the sense that there are different middle categories between honorable and dishonorable, that those middle categories are associated with grades of performance and misconduct, and that while rules exist on what types of characterization you're supposed to receive, the commander has a very wide discretion for determining which category you're going to fall in. When a service member comes to us, a Korean War, World War II even, we have some old veterans, a Korean War veteran comes to us with bad paper, we do the exact same analysis that we do for recent vets. Certainly, the VA's criteria for eligibility are exactly the same, regardless of what period of service, you were in.
Thank you, Brad. All right, our next question is, why would a sexual assault equal a less than honorable discharge? Is this punishing the victim?
Well, yes. You know, the way these incidents seem to happen is that when there is a sexual assault, that reporting it can be very dangerous for the service member who has survived the assault. You know, there's talk about changing this, but generally it can really impact unit cohesion. People don't want to hear it. There is, I think, in civilian society and more so in the military, perhaps blame the victim mentality. So yes, obviously this is unjust, but it does happen. I would recommend looking at some of the activities that SWAN has done, Service Women's Action Network, looking at, you know, how these issues are treated. So, you know, again, I mean, there's nothing more that I can say that this is blaming the victim, but it does indeed happen. And when it does, we want to be able to at least, you know, mitigate the damage to those individuals.
Thank you, Amy. Moving on to our next question. In regard to reasons for separation due to homosexual conduct, do we disregard any discharges that their status due to don't ask, don't tell, since that is no longer a reason for discharge?
So to clarify the question, is the question that, you know, currently a discharge for homosexual conduct would be automatically eligible for VA benefits? If that's the question, then under the current sorry, do you have a clarification of that?
No, the question is whether the discharge status itself would be disregarded, and that it would somehow automatically be raised to an honorable discharge, since that discharge type is a no longer valid reason for discharge.
So there is no automatic change. As Amy said, there was some talk about doing a sort of systematic review of all of those discharges to change them all, and that was, you know, Congress decided not to do that. The other option, possibility that I think the question anticipates is that, you know, when there's a reason for discharge which is no longer used, that sort of old reason kind of disappears, just sort of magically goes away, and that doesn't happen. You know, they were discharged for a reason. It was proper at that time. Their documentation says that. That's still on the books, and that's still going to be looked at and applied until it's formally changed. So someone who has that can ask for it to be formally changed through the discharge upgrade process, but it's, you know, it doesn't, unfortunately, Congress decided not to systematically review and modify those. So no, there's no automatic change.
Thank you, Brad. All right, we've got another couple of questions in this category. The next one is, what can be done to upgrade an other than honorable to a general discharge with the special court-martials?
So this is a question about discharge upgrade. I spent most of the time talking about how the VA can grant eligibility even with the discharge as it is, without changing it. And someone who has a discharge by a special court-martial, the VA can grant them eligibility even with that discharge as it is, without touching that discharge. The question is a little bit different. Can you go back to the service and ask them to issue a new DD-214 with a new discharge characterization, taking out the bad conduct discharge, giving a general discharge characterization? Yes, you can ask for that. That's the discharge upgrade process. That's the process which I described as being administratively and legally difficult. To give an example of that, you have to apply to your service department. There's not a central place the way there's a central place at the VA. There's not a central place for it. You have to apply to your service department. Each service department has 2 different boards, and you have to apply to the right one. Which one you're supposed to apply to depends on what you're asking for and how long it's been since you separated from service. Each board has its own form and some of its own procedures. We have separate materials. Source of Plowshares has prepared some materials to help people go through that process on their own. If there are any lawyers out here who want to help veterans do that, we also have a separate program, a continuing legal education program focused on, or that includes focused information on helping people discharge upgrades. The short answer is yes. If you have a special court-martial, it is theoretically possible to have it upgraded to general discharge, but unfortunately, it's difficult.
Thank you, Brad. One last question in this category.
Brad. Oh, I'm sorry. I just wanted to go back to the DADT for just a sec, which is when I think, and Brad can correct me if I'm wrong, that it was rare that someone was discharged for homosexual conduct and that was the only charge, as it were. Sometimes other charges could have been, piled on for perhaps not the most honest reasons, but so that sort of muddies the water with the DADT. Brad?
It does happen, and I can't say how often it happens, but as an example, we had someone that came in here a little while ago, served in the 70s, and they were discharged for homosexual conduct. They had a homosexual relationship. It was an officer who had a homosexual relationship with an enlisted person. So there's 2 problems there as far as the military was concerned at that time. One was homosexual conduct. The other was what they call fraternization, which is to say any sexual relationship between an officer and an enlisted person is prohibited. So that's a case where even if we would go to the service department and say, well, the homosexual charge was inappropriate, we now know this, that should be overlooked, the service would still see that fraternization activity and would still uphold the bad discharge on that basis. So that's an example of how you could have multiple offenses that would interfere with their access to upgrade just based on that homosexual conduct. In that case, you can like the fraternization rule or not, but it is in fact a rule, and that's a pretty important one in the service. It's also true that there were many cases of spurious misconduct where the command sort of piled on lots of minor things which really usually would not be the basis for a discharge. But it is potentially misconduct. So as long as it's on paper, then it would plausibly be a reason why the military could justify keeping the bad discharge.
All right, thank you, Brad, and thank you, Amy, for chiming in. I think that the discussion will hopefully be really helpful for all of those still listening in on the webinar. One last question under this category. What about corrupt leadership? So in regards to veteran separation, what can be done or what special considerations need to be made for corrupt leadership?
Well, one, we've been talking more about, in terms of solutions during this session, about solutions that one can get through the VA processes. When we're looking at corrupt leadership or even, as I said before, it's very subjective. It can go from command to command. Maybe corrupt, it could also be someone who's just really uneducated, unenlightened, and doesn't understand these issues. Those processes lie within the military, and I'll just see if Brad has any comments on ways to address that.
Yeah, an example of what we might call corrupt leadership came up a lot last year when talking about changing the rules around sexual assault in the military. Some of you may remember that there was a proposal to to remove commanders from the decision-making process about whether or not there would be a trial around sexual assault. And the reason that that was proposed was because there's been too many cases where there was a sexual assault in a unit, but the perpetrator was considered a friend of the commander, or just like, golden boys is a slang term, just like a good performer that the unit wants to keep in, doesn't want to offend. And so the commander would choose not to prosecute that offender because what might look like an old boys network or something like this. And that feels like corruption. That kind of corruption fits in the broader category of just bad leadership decisions. So on the other end of the spectrum, I was talking to a recent veteran who was a junior officer in the Marine Corps around 2006, and he was saying, yeah, he remembers very clearly. They were getting orders to deploy in 4 to 6 months, and they saw people in their unit who just weren't mentally up for it, and they knew it was because of prior deployments. They knew that they were sick and needed help, but their decision process was simply, look, we need good people. We're not a hospital. We got to get them out and get some good people in here. So they gave them a bad discharge because of behavioral problems, which they knew even at the time were symptoms of a mental health problem. That's not corruption. That's just a poor leadership choice. The remedy for that Congress created in 1944 when it said, look, we're not going to base VA eligibility on that commander's decision on the spot because we know that they're going to make mistakes, whether that's because of ignorance or corruption or just expedient decision making. We're going to let the VA with a cooler head make an overall assessment of eligibility. So one remedy is just to keep that bad discharge but still get VA benefits. The other remedy, and it is possible, but it's beyond the scope of this presentation, is to go back to the service and say, look, that was unfair, and the commander made a bad decision, and the discharge should be upgraded by the service. Those are the two remedies.
Thank you, Brad. And the questions keep coming in, so I appreciate all of your patience with us through this Q&A process, and we've got some really great questions that add some real depth to the conversation. Right, we're going to move on to some questions about benefits and eligibility. Does a veteran need an honorable discharge in order to use vocational rehabilitation and the voc rehab program under the VHA or the VBA?
No. Eligibility for voc rehab requires that somebody recognized as a veteran by the VA. The VA will recognize as a veteran anyone who has an honorable discharge, a general discharge, an uncharacterized discharge, and the VA will recognize people who have OTH or bad conduct discharges after the VA has done a review of their overall service to decide if they think service overall was honorable or dishonorable.
Thank you. That was an easy one. All right. This one kind of talks broader about the overall presentation during the second half. Does being upgraded for the sake of VA healthcare change the nature of the VBA's eligibility for compensation for such as Montgomery GI Bill?
So great question. First, a little point of clarification. When the VA looks at your discharge and sees that you have a potentially disqualifying discharge, and then looks at your overall service to give you a thumbs up or thumbs down, whether they think your service was honorable or dishonorable, I just want to be clear, they are not actually changing your discharge. You're still going to have that other than honorable, bad conduct discharge from the military. It's just that the VA, for its own purposes, is going to put you in one of two buckets, honorable or dishonorable. That's why they call it honorable for VA purposes or dishonorable for VA purposes. So I just want to be clear, you're not actually changing your discharge. You're just changing how the VA is going to look at your discharge for its eligibility purposes. The VA makes one decision, and that applies for all of its benefits. So if you request VA health care and go through the procedure to have your discharge reviewed by the, for purposes of VA health care, and if the VA says, yeah, we think you served honorably for our purposes, so we're going to give you eligibility for health care, that applies for all VA services. You are honorable as far as the VA is concerned for all benefits. So if the next day you walk in and ask for shelter services, they're going to see that you have already been recognized as having served honorable for VA purposes and let you in. Compensation, pension, voc rehab. And it works the other way around. If you apply for compensation, you are recognized as having served honorably, granted compensation. that applies for all benefits. You have basic eligibility, you're in the door. Now, the question also asked about a specific benefit, the GI Bill. So the GI Bill is the one benefit of all the VA benefits that has a specific eligibility requirement relating to your actual discharge characterization. So to get the GI Bill, Congress said you have to have a fully honorable discharge from the military. It's not enough for you to have a general or uncharacterized or OTH discharge where the VA says overall you served honorably. It's not enough to meet those basic eligibility requirements. In addition to meeting the basic eligibility requirements, for that one benefit, the GI Bill, you also have to have a honorable discharge provided, as characterized by the service department. That's the one exception to the rule that being treated honorably by the VA, HVAP, gets you in for all benefits. That's a decision from Congress. They've provided an additional layer, an additional hurdle, an eligibility requirement that you have to meet to get the GI Bill.
Thank you. Thank you, Brad. I think that that is a question that comes up a lot in whether you're in the advocacy side of working with veterans or whether you're working with veterans through VA healthcare. So I hope that clarified a lot of questions. All right, we're going to move on to another subject, focusing just on Guard and Reserves. If a Guard member or a reservist is injured during a drill weekend, does this qualify him for VA service-connected pension? I'm sorry, service-connected compensation?
So let me talk first about reservists. So a reservist on a drill weekend or during the 2-week drill period once a year, if they are injured, and if that is documented as having occurred during service, then that can be service connected, and they can receive compensation for that disability. And that's an important exception. I'm glad someone raised it. I had said that serving a drill weekend with a reservist is not active duty for the purposes of establishing veteran status, and that's true. However, if you can prove that an injury happened during that time, and if that injury causes ongoing disability, then you can get compensation for that disability that arose during that time. For the National Guard, it's different. When you are drilling 1 weekend a month for the National Guard, that's not a drill for the President. That's not federal service. That's a drill for the governor. And so the federal government is not on the hook for what happens during that time. And so the VA will not provide compensation for an injury that happens to a National Guard member while on a weekend drill.
All right, thank you, Brad. One more question. I think it's strongly connected to that topic. Would prior activation under Title X for Guard and Reserves count as prior enlistment for eligibility purposes?
Great question. Yes. So for people who aren't familiar, that Title X language refers to a presidential order. So I had said that the reserves always work for the President. That's true. Title X is a part of the statute that governs the military. The reserves is part of Title X. And everything you do on the reserves is an order under Title X. And so it's all federal service. The National Guard is under a separate part of statute. You can spend your whole career in the National Guard and never work for the President. If you receive an order from the President to work for the President, then that's federal service. That will be an order under Title X. So that's when you're talking about guards, people who serve in the Guard, that's what you're looking for. You're saying, do you have orders that say this is an order under Title X? That's how the VA knows that was federal service, not state service. Just a little footnote, if you're talking to someone who's in the reserves, you don't need that magic language, the Title X language, because reserve service is always federal service. So back to the Guards person, let's say they do get called up, they go to Iraq for a year. Needless to say, being sent to Iraq, you were sent there by the President, not by the Governor. They're going to have orders that say Title X on that. They complete that period of service. They're discharged from that period of service. They have an honorable discharge from that period of service. Yes, that good period of service where they did the full time that they were ordered to active duty, they got a discharge under conditions other than dishonorable, it was federal active service, that establishes their veteran status for the VA. And so they're in the door. They have basic eligibility for VA benefits. If subsequently they get a discharge that's less than honorable, whether that's because they are called up a second time, and from that federal mobilization they received a bad discharge, or if they were just received a bad discharge from the National Guard Bureau, that does not change the fact that they've already established eligibility with their prior period of service, which was active federal, the full-time order to active duty, and under conditions other than dishonorable.
All right, thank you. All right, we're going to move on to the next question, and this is focusing on the context of anyone serving less than 24 months. For service members enlisted less than 24 months, what if they had extended their initial enlistment?
So, so the question is, what if someone signed up to serve for less than 24 months, they complete that 24 months, they continue past, they sign up to serve for less than 24 months, let's say they sign up to serve for 18 months, they complete the 18-month period, and then 2 months later they get a bad discharge. So their total time in service was less than 24 months, but they completed their initial commitment of 18 months. I first have to say that would be a surprising scenario. I'm not aware of an enlistment contract that would be 18 months long, but let's just, for the purpose of argument, let's take that. Yeah, they were initially ordered for 18 months. That was their commitment. That's what the government asked them to do. They completed the 18-month commitment. Therefore, they satisfied their minimum time in service. Maybe a different scenario that may be more likely, a reservist is called up for 1 year. And after that 1 year, they extend for 6 months, and for some reason, before that 6 months is up, they get a bad discharge. They were ordered for service 1 year. They completed 1 year. That satisfies the minimum time in service requirement. There might be some complicated details there. So when I was mobilized for 1 year, I didn't receive a 1-year order. I received an open-ended order. And in that case, since there wasn't a defined period that I was ordered till, in that case, if I had stayed on for 16, 18 months and then had a bad discharge, that might not meet the requirement. But to take the question as asked, if there is a defined term, which is less than 24 months, and if you complete that less than 24 months, then you have satisfied the minimum time in service requirement.
All right, thank you, Brad. All right, so we've got a couple more questions, and we have way more questions than we're going to be able to get to during this time, but we're going to push on and try to answer as many as possible. Next question: are benefits available to military service cadets being discharged only after 6 months for misconduct, with the general under honorable conditions? If a veteran was discharged during basic training after a medical injury occurred, is that person eligible for VA benefits? That's actually 2 questions.
Yeah, that's 2 questions.
Yeah.
I'm going to hit the second one first. So someone's at basic training. While at basic training, they have an injury. They're discharged for that injury. Are you going to get VA benefits? Yes. You are. Yeah. You will get, if you receive a medical separation, then that's one of the exceptions to the minimum time in service requirement. You're medically retired, and so you're fine there. Usually when people are discharged during basic training, they get an uncharacterized discharge, and that's automatically in as far as VA benefits. So if that's how it happened, then yeah, you'll be fine. If you did not get a medical retirement, and this happens often, so they don't go through the trouble of the actual medical retirement process, but you do have a disability, and then they discharge you with an uncharacterized discharge for some other reason, just not fit for service or something like this. Again, you'll be fine. You'll receive an uncharacterized discharge. That's okay as far as your discharge characterization. And then as far as the minimum time in service, even though you weren't medically retired, once that condition is service-connected, a service-connected disability is also an exception to the minimum time in service requirement, so you'll be good there too. So that's as far as basic training. As far as service as a cadet, I actually don't want to answer that question right now. I would want to check. I haven't dealt with that, and I want to check to make sure that cadet time is treated the same as basic training time. I'm sorry that I can't answer that question right now.
All right. Thank you, Brad. We'll have one more question, and it's actually a scenario. So one of our attendees said, I have a friend who was medically discharged shortly after getting orders to deploy to Iraq. She was placed on medical hold and did not deploy, but was instead medically discharged for seizures and other medical conditions. Is she eligible for benefits and or for VA compensation?
Seems to me that, yes, she was medically discharged. So go ahead, Brad.
Yeah, that's what I'd say too. Yeah, so if you're medically discharged, then she almost certainly, maybe certainly, but I've never seen a medical discharge that wasn't honorable. And so I assume she has an honorable discharge. And even if she was discharged in less than 24 months, that medical separation is an exception to the time and service requirement, and so she should be fine.
All right. Thank you very much, Brad, and thank you, Amy, as well. We're quickly approaching 1 p.m., so I wanted to let the rest of you know who posed questions into the chat box that we will put together a document that answers the remaining questions that we did not get a chance to get to during this webinar. And I also want to let you know that there will be additional opportunities for continued education as well as continued dialogue within some of the topics that we just didn't really get to today. And that next opportunity will be an in-person seminar on April 15th here in San Francisco. This is a full-day forum, and it's an opportunity for behavioral health providers, advocates, and others to learn about the unique experiences of underrepresented veterans. And it will include seminars on women, LGBT, racial and ethnic minorities, male survivors of military sexual trauma, and interpartner violence. We'll also be discussing specific topics of veterans with less than honorable discharges during that conference. The seminar will count for 5 continuing education units for all of the same criteria as this webinar. All right, this concludes this presentation. Thank you to our presenters, Amy Fairweather and Bradford Adams, and to you, our listeners. Please note that each of you will be prompted once you exit the webinar to complete a brief survey to evaluate this presentation. Your feedback is important to us and it is greatly appreciated. Those of you seeking continuing education units will need to complete this information in order to receive your credit for participation in this webinar. We will archive the presentation on our YouTube channel within the next few business days. Thank you again for your time, and this concludes our webinar. You may now disconnect.